Here, I welcome to all my dear students. Today, we are going to learn consent and free consent wide agreement. So, let's start with the consent and free consent. Consent and free consent. There are something which are necessary for the formation of a contract. The Indian Contract Act mentions all these things. Free consent is one of the important characteristics of the contract. Meaning of consent. There is no contract if the parties have not agreed upon the same thing. In the same sense, if the parties enter into agreement concerning particular persons, but each has different persons in his mind, there is no agreement and no contract comes into existence between them. Definition of consent. Two or more persons are said to consent when they agree upon the same things in the same sense. If there is no consent, then no valid contracts can be created. Free consent. Not only the parties to a contract should have identity of a mind, but the consent of the parties must also be real and free. According to section 14, consent is said to be free when it is not caused by, first is coercion, second, undue influence, third is fraud, fourth is misrepresentation, and last is mistake. In this slide, now we will discuss one by one. First is coercion. Coercion is physical compulsion, fear, and even means to the goods of the person. Coercion can be done by even third party who is not a party to the contract. All these circumstances, the consent given by the party is considered under compulsion and fear of injury to a person or property, etc. Thereafter, next point is undue influence. It is noted about that the consent for the proposal must be free. There are several factors which lead the consent to be unfree. Among all, this concept of undue influence is stated as most significant if will of one party is proved to have been dominating by the influence of another party, then such consent is considered as unfree. Next point is fraud. Fraud is an act which is of a deceptive nature. It may be in the form of promise with an intention to induce the person to consent for the act which is called as fraud. Next point is misrepresentation. Section 18 aspect talks the contract as voidable at the option of the party. If the consent is obtained by way of the misrepresenting the material fact, then it is void contract. If it is ratified by the party whose consent was obtained by way of misrepresentation, then it will be a valid contract. Next point is mistake. Mistake may be defined as erroneous belief about something when an agreement is entered into under a mistake. Consent is not free. There are two types of mistakes. First is mistake of law. Section 21 of the Act provides that a contract is not voidable because it was caused by a mistake as to any law in force in India. A mistake of law is two types. First is mistake of law in force in India. A contract entered into an belief as to a law in force in India is very much valid, cannot be avoided. Second is mistake of law not in force in India. Next point is mistake of fact. According to section 20, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. A mistake of fact is two types. First is bilateral and second is unilateral. The first point is bilateral mistake. It means misunderstanding of material fact by both the parties to the agreement. Second point is unilateral mistake, where only one of the contracting parties is mistaken as to a matter of fact. The mistake is a unilateral mistake. So, these were the various points of free consent. I hope all of you must have understood these points of free consent. Next is void agreement. All agreements may not be enforceable by law. Only those agreements which fulfill the essential laid down in the section 10 can be enforced. The definition of void agreement: an agreement not enforceable by law is said to be void. The following agreements have been expressly declared as void by the Indian Contract Act. The first point is agreement made by incompetent persons. Section 81 deals with capacity of parties to enter into contract. Accordingly, minors person of unsound mind, lunatic person, and such other persons cannot enter into a contract. Next point is agreement made under a mistake of fact. Agreements made under a bilateral mistake of fact material to the agreement are declared to be void by the Act. It means misunderstanding of material fact by both the parties to the agreement. Hence, if a mistake is committed by both promisor and promisee, there is no valid proposal and its valid acceptance. Next point is agreement made without consideration. Consideration is one of the essential elements of a valid contract. In fact, without consideration, all agreements are void. However, laws has specified some exceptional situation where consideration is not required and agreements are legally converted into contracts. Next point is agreements in restraint of marriage. Every agreement in restraint of the marriage of any person other than a minor is void. Next point is uncertain agreements. Agreements the meaning of which is not certain or not capable of being made certain are void. In the essential of contract, it is clarified that the terms of the agreement must be certain, otherwise a contract cannot come into existence. Next point is agreements contingent on impossible events. Contingent agreements to do or not to do anything. If an impossible event happens are void, whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. Next point is agreements to do impossible acts. Agreements to do impossible acts are void. Next point is agreements to do an act which subsequently becomes impossible. A contract to do an act which after the contract is made becomes impossible or by reason of some event which the promisor could not prevent becoming unlawful becomes impossible or unlawful. Next point is agreements contingent on an uncertain future even if the event becomes impossible. Contingent contract to do or not to do anything if an uncertain future event happens cannot be enforceable by law unless and until that event has happened. Next is agreements opposed to public policy. First point is trading with an enemy. All agreements made between the citizens of allied countries, or where two countries are at war with each other, are considered void, illegal, and inoperative. Next point, agreements interfering with administration of justice. A contract, the object of which is to interfere with the administration of justice, is obviously opposed to public policy. Next point is agreements as regards sale of public officers. When an agreement is entered into for traffic or sale of the public officers and public offices, and the selection of an unqualified person is unlawful, such an agreement is void. Next point is agreements in restraint of trade. Every agreement by which anyone is restrained from exercising a lawful profession, trade or businesses of any kind is to that extent void. Next point and last point is agreements between lender and clients, where a client agrees to give a sum to his lender in addition to his full fees according to the success in the matter. Such an agreement is against public policy and therefore is void. So, this was all about today's lecture. I hope you all have understood the concept well. Thank you.